Hello, everyone. My name is Rehaag. I'm the director of York University's Center for Refugee Studies. I'm also a faculty member at Osgoode Hall Law School. I'm delighted to welcome you to today's panel, where we'll be discussing Canadian Council for Refugees, the Supreme Court decision that looks at the constitutionality of the Safe Third Country Agreement. This decision is an important decision, has implications in immigration and refugee law. It has implications for the intersection between administrative law and charter rights, implications about safety valves and discretion, implications about Section 7, Section 15, policy implications, foreign relations implications, political implications. So it's an interesting case. We have a wonderful panel here today full of speakers who are really well placed to help us think through some of those questions. In the interest of time, I'm not going to read out their bios. They're all very accomplished in their areas, but I'll just refer you to their bios that are in the materials, and you can take a look at that. So we're going to depart a little bit from the order that's listed in the program. We're first going to start with a presentation by two of our panelists, Josh Blum from Jared Will and Associates, and Audrey Macklin from the University of Toronto's Faculty of Law. So over to the two of you.
Thank you, Sean. So I will begin. Our draft paper is titled Always Elsewhere. And so this refers to a process where refugee rights are recognized. They're just deferred to later, to some other time in the future, to a determination in the US rather than Canada, to the discretion of border officers rather than a court. Refugees have charter rights, but this can be dealt with somewhere else in the process, maybe tomorrow, maybe yesterday, but never, never today. So I'm going to start with the quickest overview of the challenge to the Safe Third Country Agreement, or STCA. I'm going to then speak to our view that the core of the Supreme Court's decision to uphold the STCA is based on a mistake of fact. In other words, this is a case where on the court's approach, the rights aren't elsewhere, they're nowhere. After that, Audrey is going to speak more broadly to the implications of the court's approach going forward. So can everyone hear me okay? Is this mic all right? Thank you. So many people already might know the STCA challenge if you're here, but I'm going to just provide a 1-minute extremely incomplete summary of it, just for those who might not. Here we go. So under the STCA, Canada is able to turn refugees seeking our protection at the border back to the United States to have their claims decided there. The premise is that both countries are great. We have great refugee systems. We respect international law. Refugees should claim in the first place that they land. There's a lot you could say about that, obviously, but the focus of Charter Challenge has been that that premise doesn't always hold. US asylum law doesn't properly recognize certain categories of refugee claims that international refugee law does. These include gender-based claims, claims from refugees fearing gang violence, and the United States also time bars a refugee claim. So if you take too long, you're precluded from protection. This is said widely and loudly at the time that the STCA is implemented, and the UN High Commissioner on Rights and the House of Commons Standing Committee call for a discretion or an exemption for some of these types of claims, but Parliament and the executive choose to proceed with no discretion for border officers, no carve-outs for these kinds of claims. The STCA regime comes into force and it's immediately challenged, and in 2007, it's struck down under Section 7 and 15 based on the risk of refoulement for these claimants who the US will not protect. It was overturned by the Federal Court of Appeal on kind of standing grounds, and leave to the Supreme Court was denied. The agreement is then challenged for the second time after the election of Donald Trump, and this is the challenge we're discussing today. Justice McDonald of the Federal Court focuses her decision on really shocking evidence that people returned under the STCA are now being detained in US jails in really cruel conditions. And on this basis, the court strikes down the STCA under Section 7 due to the grossly disproportionate and overbroad impacts in detention. Having made this finding, the court declines to decide the rest of the arguments. But again, the judgment is overturned. The Federal Court of Appeal finds a new weird technicality to intervene on, but this time it's too weird for even the DOJ to defend. The government agrees the Federal Court of Appeal was wrong, but they defend the other outcome. They defend the outcome on other grounds. Leave to the Supreme Court is granted. And after almost 20 years, the constitutionality of the agreement is going to be decided, and it's upheld as constitutional under Section 7 with the Section 15 issue remitted back to the federal court. So to return to what I said at the outset, if you look at how a safe third country agreement operates, it's not saying get out of here, you're not from here, you have no rights. It's not saying that out loud. It's saying we recognize your right to a refugee assessment, but under our safe third country agreement, which has a preamble that is a love letter to non-refoulement and refugee protection, your rights are just over there. They're elsewhere. We hear you, we see you, you're valid. You just have another process over there, and it's fine. But it's interesting that in a challenge to the premise that it's not fine, that the process elsewhere actually doesn't protect many refugees, the Supreme Court's decision follows the same analytical structure in deferring refugee rights elsewhere. In this case, to safety valves, what it calls, or to administrative discretion. So in CCR, unlike many other cases, the Supreme Court says loud and clear that refugees have equal Section 7 rights. And it recognizes evidence of very serious harm in the record. But on the invitation of the DOJ, the court looks through other parts of the Immigration and Refugee Protection Act, and it's a huge, inscrutable statute. And it finds discretionary immigration status applications that have never been used in the STCA context, and that it's questionable how they could even be used in this particular context of the border. And even though the guidance for border officers is quite clear that they have no discretion when it comes to the STCA, there's no mention of these applications in any of the operational guidance. The court finds no, these are in the law. These are actually well-tailored safety valves that can cure any issue. This is an administrative discretion that could be exercised constitutionally. And this is where any charter problem should be addressed over there. And because your rights are with immigration officers at the border, if there are any problems going forward, it's actually not a ground for a Section 52 charter remedy striking the law. No, it's now maladministration. It's a failure of the officer to exercise the discretion to cure the breach of the charter in that individual case. This is problematic in itself on constitutional law grounds, but it's especially jarring if you know what the form that the court has deferred the charter issues to actually looks like. Because in practice, despite the very reasonable, sensible tone of the judgment, deferring charter rights to a refugee claim at the Canada-US border is madness. Refugees arrive at the border with no counsel, speak no English or French, often have a day of travel and have crying children in their arms. And the court's view is that they would somehow on their own raise these constitutional issues based on evidence they would have about defects in the US asylum system's ability to decide their claim. And they'd have to do it in a couple hours because removal must be enforced, quote, as soon as possible under Section 24 of the Act. And in practice, this process takes a couple hours. It's still in the guidance today after this decision that it should be the same day. But if those practical issues were not enough, the decision is also wrong on its own terms. And that's because the court recognized, when it's discussing what a safety valve is, when discretion can uphold a law, it recognizes that judicial intervention can't be a safety valve. The government can't defend a law by saying, if there's a charter violation, just go to court. If you need to go to court to stop unconstitutional effects, the law is unconstitutional. Two of the litigants in this case who managed to avoid removal after an STCA ineligibility are the only times this is known to have happened in the history of the STCA. And it was because they had countless lawyers and 3 national public interest organizations involved in their case, looking to challenge the regime after the Muslim ban and after the election of Trump in the US. And the only way that the litigants could avoid removal to bring this challenge was going to court. With the help of these lawyers, they brought emergency judicial stays to challenge the agreement. They only sought any other immigration application once they had gotten the judicial stay, which is what allowed them to stay in Canada. What's very interesting in the judgment, and also in my opinion, the court telling on itself, is that the facts write the judicial stay, the judicial intervention that makes it not a safety valve, out of the story. The judgment repeatedly and wrongly states the facts that if it was actually these other immigration status applications that are what stopped removal, but that's not the case. They could only get to those applications through a judicial stay, which on the court's own definition can't be a safety valve. So to conclude, the court could only find otherwise, could only uphold the law in the way it did by repeatedly misstating how the applicants could avoid removal. This is why we say that this decision, which allows the Safe Third Country Agreement to continue to operate as we speak, is based on a mistake of fact, and it's wrongly decided on its own terms. I'm going to now pass the mic to Audrey for more on the broader implications of the decision. Thank you.
So in Alice in Wonderland, the Red Queen tells Alice that she gets jam every other day. And the rule is jam tomorrow, jam yesterday, but never jam today. So if charter rights are your jam, then the court in STCA assures you that you have jam. You have rights, just not today, not here, not from us. And I think Josh did a wonderful job of laying that out. You have rights, but not here. They lie in the US. You have rights, but not today. And in this, I think Josh has really spelled out how the court bends the facts. It discards evidence. It invents a process that is, as the federal court found, illusory, in order to say, well, you might have rights, but they haven't been violated here. And I pause just to say, quite apart from what one makes of this judgment and this issue, the fact that the court would do that raises real concerns about basic rule of law principles, both with respect to the exercise of appellate adjudication, but also, for example, in claiming that a process exists and is actually practicable when it's not, right? There's a kind of rule of law concern about that as well. Rights exist for you, but they're not in the form that we as a court will adjudicate. Instead, they lie in the form of discretion that will be dealt with by somebody else somewhere else in another forum, namely at the border within minutes or hours of your arrival and before you are turned back, as it were, and as Josh explained. So there is in this judgment a very positive assertion. I know Jackie will talk about it later, a set of analyses that say the rights are engaged here and there is causation or causality under Section 7. And so you have jam. That's important, and I want to emphasize it is important because of a long line of what might be called exceptionalist jurisprudence, primarily from the Federal Court of Appeal, but some from the Supreme Court of Canada, that amounts to we somehow address the engagement and presence of rights in the immigration context differently, and they don't, in a sense, kick in, if you will, until basically the individual concerned has one foot on the tarmac, one foot on the plane. So for the court to say, no, 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 the charter engagement and causation permeates the immigration process, which is long, complex, and distributed across a number of provisions in the statute. That's really important. So you've got the rights, but the concern is you never seem to have them right here, right now. So what I want to speak about here briefly is what do you get? And what you get here is a form of discretion. That is, discretion through this concept of safety valves becomes the kind of technology through which the constant deferral is managed. And I want to just briefly say, so what's going on with technology, with the technology of discretion? It is a powerful technique, if you will. And in the immigration context, what I think it's doing is this. You've got, in a sense, two logics at work here. One is what I'll call the political logic of sovereignty. And under that logic, states have a right to exclude and expel the non-citizen. And an implication of that is that if states have that right, then their decision to admit or allow someone to remain is entirely within their discretion. It cannot be other than that if they have that right. That's the political logic of sovereignty, that sovereignty subsists or is instantiated by the degree to which you exercise full control over the border. A different logic is the logic of rights. And in the logic of rights, or constitutional logic, states have power. And that power includes, of course, the power to regulate migration and borders and to admit or exclude or expel. It's a power, but in constitutional logic, of course, power is constrained by rights, but the rights holders are individuals. And that means that if an individual's right is violated through the exercise of power, then power cedes place to the right. So you've got this competition, if you will, between two different kinds of logic. What discretion does here is subordinate the logic of rights to the political logic of sovereignty and discretion, and take what one might think of as the rights that individuals hold under the charter, turn it into or make it vindicated only through an exercise of discretion exercised by a border official, you know, in very exigent circumstances. And that is to say that that the vindication of a right is transmuted into a request or for benevolence or for a privilege that may or may not be granted through the exercise of discretion. This plays into larger issues about the role of discretion and the role of charter rights within that. And so this has broader implications, I would suggest, for charter adjudication, and I'll stop there.
Thank you, Audrey and Josh, and I hope we get to return to those questions in the Q&A session. Our next speaker is going to be joining us virtually. It's Jamie Liew from the University of Ottawa's Faculty of Law. Jamie, over to you.
Thank you, Sean, and thank you to the organizers for the invitation. It's an honor to be at this annual gathering of constitutional law experts and alongside my distinguished colleagues on this panel. I'm attending today from Hawaii, where I'm a guest on the land of the Kanaka Ma'ali, and I'll be picking up where Josh and Audrey left and continue talking today about the Supreme Court's finding that legislative safety valves ensured the SCCA scheme complied with the principles of fundamental justice. The court, however, found that if the safety valves are illusory or otherwise inadequate to respond to potential harms, or if, for example, the CBSA officers acted unreasonably or unconstitutionally in their treatment of some returnees or in their interpretation of the legislative scheme, including its safety valves, the application of the scheme would not be compliant with Section 7. So here, what's interesting about this decision is that they do qualify that safety valves must be operational or responsive to the potential harms or to the principles of fundamental justice in the Section 7 analysis. My talk with you today will interrogate how this approach overall has complicated charter litigation and, practically speaking, has created immense distance between litigants and access to charter remedies. Last spring, I had the distinct pleasure of commenting on the SCCA case before the decision came out at an admin law conference, and I was sitting next to the great Barb Jackman, who many of you know, who actually didn't talk much that day because she had lost her voice temporarily, but being the legal giant that she was, when she did speak, she said something very interesting, which has haunted me ever since. And she commented that the trend for litigants in charter litigation to submit social science research is troubling. And some of you will remember that following the Supreme Court's decision in Bedford, there was much acknowledgement on the fact that the court's findings relied on social science research to understand the lived realities and impact the impugned legal provisions had on sex workers. This decision seemed to give prominence and elevated social science as evidence essential to ensuring how law may be experienced by marginalized persons. And as Sonia Lawrence wrote, heading into the future following Bedford, there is new law, but no data on how this law works. And there is a need for solid scholarship. And since the legislative amendments were made following Bedford, more research has been undertaken. And before the Supreme Court today is yet another case dealing with the constitutionality of some of the criminal provisions targeting sex work. It may seem strange to you to see me as a legal academic to be wary about undertaking research, but I want to put in front of you today how the necessity for expert social science research impacts first, the analysis, the legal analysis, and secondly, how this affects access to justice. Now, immigration lawyers are no stranger to safety valves. For decades, our clients were told, even though on the face of it, there is a charter violation, the fact that you could apply for status elsewhere through a different application, as Josh and Audrey had just talked about, somehow erases the impact of the impugned provision. Permanent resident applications on humanitarian compassionate grounds, pre-removal risk assessments, for example, among others, have been identified frequently as a mechanism that is available. Courts rely on the existence of these applications in legislation as saving any impugned scheme from potential findings of charter violations. And the reliance is based on simply the existence in legislative text and nothing more. This kind of legal analysis begs a few questions. What constitutes a safety valve? How does one identify it? Is its mere existence in legislation sufficient? Should identification of a safety valve include an assessment of whether it complies with the principles of fundamental justice before taking for granted that it does? Should the burden be on the party relying on the safety valve to show it is accessible and procedurally fair? Should the test include an assessment of whether the safety valve is responsive to the deprivation of the charter right? Mere existence is not the test, I argue, but I think what we need is an assessment of the operational and the responsiveness of the safety valve. That should be considered in any legal analysis. It has by default, as we've seen in the immigration law context, become a burden on the litigant to rebut the presumption that a safety valve is viable or that it is operating the way that a court assumes. This is where social science expertise comes in. Very recently, in preparing for an admin law case I'm involved in, I relied on research that I was part of, one produced with Jennifer Stone and Prasanna Balasundaram, that involved not only doctrinal case law research, but ethnographic surveys of lawyers on the impact of a regulation that kept families separated permanently, and the ability to cure that harsh application of the regulation through safety valves. This research was published in 2017, debunked illusions that the safety valves were operating as expected, and led to the government to create a pilot program to try to address this. The research identified troubling trends with regards to the safety valve. First, that it took years to obtain decisions. Second, there was low acceptance rate. And third, factors such as the involvement of children and the innocent or non-fraudulent reasons for why they were asking for relief didn't tip the balance. In other words, the safety valve did not provide relief in heartbreaking situations where one expected. Following the decision from the Supreme Court on the STCA, Jenny, Prasanna, and I, now with Pierre-Andre Theriault, are starting discussions again about how we needed to provide more clarity to courts on the viability of various safety valves identified by the courts in the decision. We borrowed our methodology from our previous research project and are currently undertaking a lawyer survey again. If there are any immigration lawyers in the room, please do reach out to me if we have not reached out to you already to participate in this survey. And while we're still in the midst of collecting data, I want to share with you some of our preliminary findings in response to the Supreme Court's assumptions. They confirm what many of us already know, that safety valves are complicated and that laypersons don't really know they exist. The menu of safety valves are not offered at the borders or ports of entry or even by immigration officers in other contexts. Lawyers commented on how the border, the only thing that is effective is a judicial stay of removal, as Josh mentioned, which is not even a safety valve. And emergency stays are not realistic to mount at the border. Lawyers also commented on, quote, the ridiculous amount of work, quote, needed to mount various applications. Lawyers commented on the low acceptance rates of the safety valves and how they themselves had to mitigate expectations of their clients and the viability of the application. And finally, lawyers commented that even in very compelling, heartbreaking cases, applications are denied. And this is just a snapshot of what we're capturing. Already, we're getting a sense that safety valves are illusory. And as researchers, we hope this data will be published in time to make an impact on the ongoing litigation. Now, why am I telling you about this? As many of you have undertaken qualitative research know, it's not a light endeavor. It's one that requires time and resources. This research project alone involves numerous students and lawyers and professors. I raise this as a reality check for those of you who are thinking about access to charter remedies and what this means for a layperson to make a charter claim. In engaging in this dialogue with the courts, lawyers must now produce social science research to counter assumptions and understandings of safety valves. For laypersons seeking consultations with lawyers, how many have been told that their claim will be futile because there simply isn't anything out there to counter the legal narrative that they have viable alternatives? On a more global scale, what's happening in the immigration law context should be a warning to other legal contexts about how much distance is being created between persons directly impacted by the law and the ability to ask for charter protection. What does this legal device of identifying safety valves do in thinning the protection of the charter? Should we as lawyers and scholars be pushing back on this conceptual device meant to keep frivolous claims at bay? Should we be taking a more active role in asking the courts how they must arrive at identifying a safety valve? What elements should be considered? Whose burden should it be? I return to Barb Jackman's comment. When she first uttered it, I stated then that I thought it was important for the courts to be receptive to social science expertise to help demystify how the law operates. However, I'm coming around to Barb's view after much reflection and after digging deep into the labor ethnographic research and wonder how many litigants have been told they don't have a chance or are being denied a true examination of the merits of their case because of this barrier now in the process of charter litigation. And perhaps rather than emphasize dialogue through expert research, we should be pushing back on the actual test of what is a charter violation, what burden should be shifted back to the government in cases where there's an imbalance of power and where there are vulnerable people making such claims. Thank you.
Panel. Also, I'm a litigator, so I prefer to stand when presenting. So I am tasked with actually providing a little bit more of an uplifting story from CCR. We've heard some of sort of the negative components of it, and I don't want to detract from any of those. But there is a bit of a bright light in the decision that I want to cover. So for a long time, as my colleagues have indicated, there seemed to be one set of rules for Section 7 engagement in the immigration context, and one set of rules for Section 7 engagement outside of it. For example, within the immigration world, a Section 7 interest was found not to be engaged, even where removal resulted from the separation of a child from their parent, or where removal uprooted a person who had resided in Canada for 45 years, forcing them to leave their entire family in Canada, returning them to a country they'd been to once in that 45-year period. It was even found not to be engaged where they removed a person who had struggled with significant addiction and mental health issues from their entire support system in Canada, where they had lived for 50 years, was not fluent in the language of the country they were being returned to, and where psychological evidence that was accepted by the court found, and I quote, that the person would likely suffer expedited psychological deterioration, incapacitation, and a gravitation toward passive and/or active patterns of self-destructive behavior that would likely result in the shortening of their life. Section 7 was found in each of these cases to not be engaged. Causation assessment in immigration cases hasn't been a lot better. So in contrast to other multi-stage proceedings like extradition and the criminal law context that I'm sure many of you are familiar with, courts have repeatedly found that Section 7 is only engaged, and as my colleagues noted, at the very end of the process, as I think Audrey said, when you've got one foot on the tarmac and one on the plane. And that's not actually an exaggeration. As somebody who actually just 2 weeks had one of my associates arguing a stay 2 hours before the person was set to leave Canada. So to give you an example, the court has essentially said in these cases, it's too remote, right? Up until this point, it's too remote, it's too far away from these initializing procedures that eventually lead to the person's removal. Let me tell you a little bit about these initializing procedures. So an admissibility hearing would be one of these. An admissibility hearing, here you assess whether or not somebody has engaged misrepresentation, criminality, security issues, such that they are no longer allowed to stay in Canada. If a decision is made that they are inadmissible, at the hearing, they are issued a removal order. I was an ID member for a brief moment in time, and we actually handed it to the person, their order to leave Canada. The law, as also my colleagues have noted, is that CBSA has to enforce that as soon as possible. That is the law. And so any efforts that are taken above and beyond that, these so-called safety valves that my colleagues have talked about, is all that stands in the way of their potential removal from Canada. And yet, despite this, the court had repeatedly found that Section 7 was not engaged at those processes that led to the issuance of the removal order, but was only engaged much, much farther down in the process. For years, advocates, including many of my co-panelists, have tried to point this double standard out to the courts without any avail, until CCR. See, here's the bright star. In essentially 3 paragraphs, paragraph 7, 72, and 73, in case anybody wants to run out and read them, the Supreme Court provides an invitation, if not an outright direction, to lower courts to finally realign the Section 7 engagement jurisprudence in the immigration context with its established jurisprudence elsewhere. In these paragraphs, the court clarifies its comments in 2 previous decisions, and this was the Supreme Court's decision in Febles, which dealt with exclusion from refugee status, and in B10, a case that dealt with the interpretation of people smuggling. In both these cases, there was essentially a paragraph or 2 that had kind of been thrown in, which noted that we could not consider Section 7 interests until these final stages. An enormous line of case law has sort of built off of these 2 paragraphs or 3. The Supreme Court in CCR directly addresses its dicta in these 2 cases and essentially says, I know that's what you think we said in those cases, but you can't actually rely on that and you can't actually take it that way anymore. In doing so, the Supreme Court essentially throws out at least a decade's worth of jurisprudence in the immigration context on Section 7 engagement, which again has essentially been dealt on the opener that was in these 2 cases. The Supreme Court in these 3 paragraphs also firmly directs that an assessment of the potential safety valves in a potential case can only be considered at the 2nd stage of the Section 7 analysis, when you're looking at whether or not it's in accordance with the principles of fundamental justice. No longer can these purported safety valves act as a barrier or a block from actually being able to ascertain whether Section 7 of the Charter is engaged. The court also explicitly notes that safety valves, that their assessment is not something that can be done at all in that first part. And if it is, that constitutes an error in law. It also provides a few other comments. I'm going to highlight 2. Again, there's a lot in these 3 paragraphs. I do really recommend that you read them. The 2 comments is that Section 7 should be, in the immigration context, should be read in accordance with the established case law in Section 7. And then it provides this helpful reminder that in other contexts, like extradition, Section 7 has been found to permeate the entire process. So where does this leave us with respect to Section 7 engagement? So the federal court hasn't weighed in on this yet. So it really depends on who you talk to. My friends at the Department of Justice might have you believe that nothing has changed at all. In at least 3 cases that have been raised post CCR coming out, the government has taken what I actually find to be a remarkable position that nothing has changed. And I should say, most recently, these arguments have been raised in the cessation challenges to the cessation regime, whereby there is a constitutional challenge to when you can cessate somebody's refugee status and the implications of that, which I am intervening on in behalf of the Canadian Civil Liberties Association. So I'll just put my bias out there on the table. But essentially, their arguments are in 3 parts. First, given the context of the STCA, we can't really apply it anywhere else. I mean, I think that just the straight up wording of those paragraphs that I'm referring to make it very clear that this is talking about more than just something that happens at the border. It's talking about admissibility. It's talking about exclusion. It's talking about, in my view, a cessation as well. The second argument that the government of Canada is putting forward is that the Supreme Court didn't do what it's supposed to do when it overturns case law. And to this, I would say, I don't think the Supreme Court really saw themselves as overturning case law so much as telling the courts to get back in line to what the established case law actually is, which means they don't have to do what they would typically do in cases where they're overturning it. And finally, and this one's my favorite, the Canadian government argues that we've been doing it the right way all the way through, just keep on going. To which I say, the Supreme Court says we can't do that anymore, thank God. So where does CCR leave us? The thesis of my paper is that CCR should change how courts approach Section 7 engagement in the immigration context in 3 substantial ways. First, and the clearest from the court's decision, is the requirement that safety valves, what I just spoke about, cannot preclude a finding that Section 7 is engaged. The court has clearly found that it's an error to hold that the fact that there might be something that they can access later down the road does not preclude a court from having to assess whether Section 7 is engaged right now. So all of the cases that say Section 7 of the Charter is not engaged in early stages, they're all now bad law. Second, courts must assess causation in the immigration context according to the sufficient causation standard in Bedford. Seems relatively straightforward. Everybody really likes to talk about the sufficient causal standard from Bedford. I'm not sure people are actually applying it correctly. And so the Supreme Court essentially says, okay, now we need to do it right. And what this means for immigration, I would submit to you, is that now things have to start when somebody is potentially going to be subjected to a removal order. So at all of those processes, the cessation hearings, the exclusion issues at a refugee hearing, and admissibility hearings, that's where it has to start. And the reason is that all of those proceedings are a precondition for somebody being removed from Canada, right? You cannot get a removal order. You cannot ultimately be removed unless you go through one of those proceedings, unless you get a removal order, unless you are excluded from refugee protection, or unless your refugee status is cessated. In addition, it's actually one of my co-panelists wrote in an article that was affirmed by the Supreme Court in CCR, there's a lot of other downstream effects between these initial proceedings and the proceedings that come down the line right before removal. They share factual findings. So often a decision maker before the Immigration Refugee Board will make a factual just be parroted by later adjudicators who feel like they can't actually do anything about those factual findings, or at least there will be a presumption that they cannot. That can be often very hard to rebut in later proceedings. There's overlapping legislation that is, can be interpreted one way by an adjudicator at the IRB, then again can be felt that they can't change that later down in the process. So there's other reasons why, frankly, I would submit it would be obvious that a sufficient causal connection is made out between those initial proceedings and the ones that come down the road. Third, and finally, in light of the Supreme Court statements in CCR, the threshold for finding that a Section 7 charter interest has been infringed should also realign with established Section 7 case law. Now, we all know that charter engagement has 2 steps, right? We have sufficient causal connection, and we have to look at whether or not the scope of the interest is actually something that's covered by Section 7. The Supreme Court has repeatedly defined engagement of these interests broadly, requiring a challenger only to show that the government action engages those interests in the sense that it causes a limitation or negative impact on an infringement of or an interference with those interests. Now, while I admit that CCR doesn't provide as clear a roadmap for realigning this determination with the established principles, there are several reasons why it should be sufficient to ensure that the established principles used to ascertain Section 7 engagement in all the other areas of law should also be applied in the immigration context. First, CCR emphasizes the use of established case law. So it really highlights how courts need to apply the established jurisprudence in all areas of Section 7, including in the immigration context. I think this sends a strong message to the lower courts that it's no longer appropriate to apply these differential standards. Second, there's an outright acknowledgement in the immigration case law that the standard that's currently applied is not in compliance with the current standards. In the case of Revel and Moretto, the court actually says, yeah, we know that this is well beyond the standard in GJ, but this little case called Metavarski says it doesn't matter. We can't actually find that Section 7 of the charter is engaged. And so I'm going to end my comments with a little bit about Metavarski, which seems to be kind of the root of this differential approach to Section 7 with regards to the scope of the interest. Metavarski, when you read these cases, you think it was like this vast litany of all things Section 7. In a 51-page decision, it has 3 paragraphs that are really short and barely brushes it aside on the Section 7 issue. And I would submit to you, it is, or like in those three paragraphs, there's essentially a line that says, Section 7 is not engaged by removal. That has been changed as a result of Sharkawi, a security certificate case, which found that actually it can in certain circumstances. And I would submit to you that when you apply CCR to Metabarsky and the reasoning of not allowing cases that sort of an obiter, detract from established Section 7 principles to overtake them in certain cases, that we actually should go back, reassess Metabarsky and find that no, actually, it can no longer stand to allow this double standard between how we address Section 7 interests within the immigration context and how we address them outside of it. So all of that to say is, if we get there, if the good news here that I'm trying to bring is that if we get all three of those things, if the federal courts, when they're looking at this, find that all three of these have been met, we will finally be in a world where a woman who's being removed from their child or a long-term permanent resident who's being uprooted from their family will finally get access to the same Section 7 charter engagement principles as everybody else. Thank you.
Thank you, Jackie. It's nice to hear some optimism about a decision that I find quite problematic. Our final group of speakers are Sharry Aiken and Colin Gray, both from Queen's University's Faculty of Law.
Thank you, Sean. Yeah, you do it. Okay. Terrific. Hi, everyone. So we're going to focus on a small but potentially significant part of Justice Kassir's opinion in CCR, namely the decision to send the Section 15 issue back to the federal court for determination in the interests of justice. Arguments made before the federal court and federal court of appeal that the Safe Third Country Agreement and its implementing regulations lead to adverse effects discrimination against women fleeing gender-based violence and persecution. However, the federal court declined to address the Section 15 issue, having decided in favor of the claimants under Section 7. The federal court of appeal refused to deal with the Section 15 issue as well. It was unnecessary since, in the court's view, the challenge to the Safe Third Country Agreement scheme had been improperly constituted. Justice Stratis further reinforced that, and I'm quoting, Section 15 does not enjoy superior status in the hierarchy of rights, and while anxious scrutiny in this area is called for, in the absence of factual findings, a Section 15 analysis was not justified, he suggested. At the Supreme Court, Justice Kassir found against the appellants on the Section 7 issue, but reopened the door on the question of Section 15, stating that claims based on Section 15 are not secondary issues only to be reached after all other issues are considered. The charter should be treated as if it establishes a hierarchy of rights in which Section 15 occupies a lower tier. Sorry, the charter should not, okay? So that, in other words, roundly rejecting what Justice Stratis had to say. Accordingly, the case was remitted back to the federal court. So what we're going to talk about in our few minutes is to basically give a very brief historical context for Section 15 in the immigration and refugee law area. We're going to explain why the court's decision to send the matter back is potentially significant. We're going to give an overview of the claimant's Section 15 arguments as initially presented before the federal court and federal court of appeal, before turning finally to highlight some of the new evidence and where things might go from here in terms of legal doctrine. So that's the agenda. First, with a bit of history. So there have been more misses than hits, as you can see from our targets. Justice Kassir's decision to send the Section 15 issue back to the federal court signals that equality rights issues should receive more attention than they typically do and typically have in the immigration and refugee law domain. Indeed, the record on Section 15 cases in the domain of immigration law offers up a lot more misses than hits. Those misses are arguably attributable to the notion of immigration exceptionalism as elaborated by a number of scholars, including Joss and Audrey in separate articles. The idea that what matters in this domain is the power of migration control, which authorizes and indeed legitimizes norms and laws that draws distinctions between persons that in any other context would be considered discriminatory. So let's go back in time to one of the very foundational cases, that of Andrews and Law Society in British Columbia. Of course, the whole equality rights era was launched by this case, a case that we might consider to be inside the immigration law basket. Mark Andrews had sued the Law Society of BC, claiming that the restriction of Law Society membership to citizens alone was contrary to Section 15 of the Charter. The Supreme Court held by a 4-2 majority that non-citizenship was an analogous ground and that citizenship requirement of the BC law infringed Section 15 and was not justified. In her concurring opinion, Justice Wilson found that relative to citizens, non-citizens are a group lacking in political power and as such vulnerable to having their rights to equal concern and respect violated. This was a solid win, but in the Andrews context, it was perhaps easier for the court to come to this conclusion. Andrews himself was a white Oxford-educated lawyer and exactly the kind of non-citizen, at least historically, to be afforded preferential treatment under Canadian immigration law and policy. Since Andrews, the courts have been unreceptive, dare we suggest even hostile, to claims based on adverse effects, and have firmly pronounced that immigration status is not to be considered an analogous ground under Section 15. But to be fair in this regard, the Supreme Court has only accepted 3 such claims to date outside of the immigration context, namely in Eldridge, Freend, and Fraser. The rare equality rights victory in immigration or refugee matters has been where claimants can establish distinctions with a disproportionate impact on certain categories or classes of refugees or immigrants, Andrews aside, rarely if ever between citizens and non-citizens. And in that regard, I'll just share a brief anecdote of my oral arguments in the Sharkawi case before the Supreme Court of Canada on behalf of the intervener, Canadian Council of Refugees. We decided amongst all of us interveners that the CCR would go first because we wanted to put the Section 15 argument squarely before the court. The entire time of my 15-minute intervention, Chief Justice Macklin looked at me with her brows furrowed and did not ask a single question. And the Section 15 arguments that we raised didn't even merit a mention in that decision. So just say. We're ready for the next slide. So more representative, indeed, of the outcome of Section 15 cases generally is perhaps Toussaint in Canada. Does that mean I'm already at my time? No. Oh, phew. Okay. This case concerned a federal program created by an order in council that made healthcare available to some non-citizens, like refugee claimants, resettled refugees, and victims of trafficking, but not to others, including individuals without immigration status, such as Nell Toussaint. Nell Toussaint came to Canada to visit and stay to work. She toiled for almost a decade as a car parts assembler and a general laborer. Various tax and other payroll deductions were taken from her paychecks on a regular basis. When she fell seriously ill with complications related to diabetes, she was informed by Canadian authorities that her illness and her inability to attain health care for her illness were essentially her problem. Lack of adequate health care resulted in amputation, a stroke, and blindness, and ultimately her death. Ms. Toussaint passed away just last year at the age of 53. Meanwhile, the Federal Court of Appeal rejected the claim that the denial of health care under the federal program to Ms. Toussaint created a distinction based on an enumerated or analogous ground and was discriminatory. Justice Stratus of the Federal Court of Appeal suggested the appellant has been denied coverage because she did not enter as an applicant for permanent resident, is not a person under immigration jurisdiction, and is not a person for whom the immigration authorities feel responsible. That's a direct quote. So the denial of the charter claim ultimately rested on the idea that Canada has discretion to make distinctions between people like Ms. Juzet and others. And on that note, I'm going to hand things over to Colin.
Thanks, Sharry. Yeah. Sharry will be back, so you'll have another chance to applaud. So I guess the message of the presentation so far is that, sort of there's one hopeful way to read Justice Kassir's opinion, and that is that in addition to sort of opening up immigration law, refugee law more broadly to Section 7 engagement, it may also signal sort of a renewed seriousness with respect to Section 15 in this area as well. And this has, I guess, then the point of the slide is that this has the potential to open a can of worms. But ultimately for the good, if you think of a role of a constitution, is to legitimate state laws and actions. So as one example, we might ask why it's not discriminatory to deport permanent residents, but not citizens who've committed certain crimes. On its face, that does seem like a distinction that disadvantages a group characterized by an analogous ground. Or you might ask why it's acceptable to have programs that are more favorable for Ukrainian refugees than for Afghan refugees. So distinctions of this kind are really rife in immigration law, and they're also ripe for an inquiry into whether or not they're unjustifiably discriminatory. So in the next few slides, we're going to look at the distinction that's at issue in the CCR case now that it's been sent back. So questions of this kind are at issue in CCR, but within the specific context or with the specific contextual considerations that arise with respect to refugees, refugee claimants, and the intersection of the Charter and international refugee law. So in this slide, and the next two after it, we'll be presenting some of the arguments made by CCR at federal court. And the test that they applied, which I can't read from here, is from the Tepotat case, so I won't read it. But I mean, one of the interesting things from the case is that, or if you go back and you look at the materials in the cases, is that it's a real, you see the Section 15 sort of jurisprudence evolving as the case goes through the sort of different stages. And so at the federal court and at the Federal Court of Appeal, the first argument that was made by the by CCR, by the claimants, was the argument that the Safe Third Country implementing regulations create a distinction because of barriers that women face making gender-based persecution claims in accessing protection in the United States. And we'll explain that argument in the next couple of slides. And second, sort of for the second stage of the Section 15 test, it was argued that this distinction is discriminatory because this kind of blanket ineligibility fails to respond to the actual needs of women facing gender-based persecution. So the argument was that blanket ineligibility perpetuates the view that gender-based persecution claims are less worthy of attention because they're fundamentally private in nature, and also perpetuates the systemic disadvantages faced by women making such claims generally. And just to illustrate sort of the basis for this argument, one example of such a barrier, and it's not the only one, focuses on the way that the American legal system interprets the phrase particular social group. So to be a refugee, you need to fulfill the definition that's on the slide. You need to face a well-founded fear of persecution based on one of 5 grounds. If you look at that definition, gender, sex, etc., are not named as grounds. So for women to make out a refugee claim based on domestic, sexual, or other gender-based violence, they need to argue that they are facing persecution because they belong to a particular social group. 2 minutes. Okay.
Okay.
Yeah. And so I'll just finish this slide and hand it back to you. And so in Canada, gender is recognized as a particular social group. But in the United States, in contrast, to establish a particular social group, you need to show things that you don't need to show in Canada. You need to show that gender or sex is an immutable or fundamental characteristics, as it is, but you also need to show that the group you're proposing has social distinction, that it's perceived as a group in society, and that it has particularity, that it has clear boundaries, that it is not vague or amorphous. And the American sort of jurisprudence, decisions by tribunals and courts have been inconsistent in applying these requirements, but in general, they make it harder to succeed in gender-based claims.
We were going to go ahead and highlight some of the salient elements of the new evidence that's being brought forward to the federal court. But I'm not going to go into detail in relation to that evidence. Happy to talk about it in a discussion. I actually would like to hand it back to Colin because I think our concluding piece is probably the most important part of this presentation in terms of what are the implications of all this. So.
Okay, so I'll
Actually.
try to finish quickly. So Justice Kassir, in sending the case back, referred to novel legal arguments that had to be addressed by the lower courts, especially those relating to causation and equality rights in the international context. With respect to causation, the issue is really whether or not, or should be whether or not, sort of the disadvantage faced by women refugee claimants in the United States is caused by the Safe Third Country Agreement, or whether or not it's caused by, persecution or failures of protection in their country of origin. That doesn't seem like that hard an issue because in the Sharma case, the Supreme Court says that the government action or law only has to be a cause, doesn't have to be the dominant or the sole cause of whatever disadvantage the claimants face. What's perhaps a little bit more interesting, and that we'll end on, is the idea that in the international refugee law context, we run into this problem in thinking through what discrimination might mean. Right. So in the international context, one way to frame the issue is to begin with the proposition that refugees and most of those seeking refugee status are already disadvantaged. They're in fact, sort of by definition, among the most disadvantaged people in the world. At the same time, the standards of who counts as a refugee is fuzzy at the margins. Right. So claims of discrimination end up either being too powerful or too weak. They can be, or they may be too powerful because to be a refugee is to be a person who faces discriminatory persecution. Therefore, any failure to abide by the norms of international refugee law will exacerbate or perpetuate disadvantage. On the other hand, claims of discrimination may be too weak because there's no definitive arbiter in the international refugee law regime of what the international standards for applying the refugee definition are. Even UNHCR doesn't fill that role. So within the reasonable range, it's difficult to show that a particular interpretation, American, Canadian, is actually represents a failure to abide by the norms of the 1951 Convention. So the issue is, what do equality rights mean in the intersection of Canadian constitutional law and international refugee law when the demands of international refugee law are not settled? And so we think, and this is a less hopeful note than we started out with, probably what this means is that the courts will end up applying what, for lack of a better word, could be described as deference towards the American system, right? And there are indications in the CCR case, sort of reasoning that Justice Kassir provides, that will probably transfer over to the Section 15 context. Mention of comity and sovereignty, sort of that needs to be shown to the American system. The idea that the American system doesn't need to mirror the Canadian one, but in the CCR case, sort of will only be found to violate the principles of fundamental justice if it's fundamentally unfair. And then, as Jamie and Josh and Audrey have talked about, the idea that discretionary safety valves might be used to show that, in fact, the application of the Safe Third Country Agreement might be tailored to the actual needs of claimants. Okay, and then I will end it there. I hope we didn't go too far over time.
Thank you, Colin and Sharry. So we have a few minutes for questions. We also started a few minutes late, so I hope I can end this session just a little bit. Does anyone have any questions? Comments? Maybe you should go up to the
Thank you to the panel for a really interesting discussion. I admit I've not read the decision, that's why I'm here. But I'm interested in, I've read other cases over the years that are kind of speaking to me. And so I'd like your input on this. In particular, I understood that the Supreme Court of Canada told us in Vavilov that it was going to charge courts with being a lot more serious about enforcing rule of law principles in administrative review. So I guess it's kind of well, like where's Vavilov in that discussion? And a lot of the way the problem is identified by many of you reminds me of the Little Sisters problem, which is a border control issue. Materials, not people, similar, I guess. And so I'm just wondering, where is Little Sisters in this? I mean, are we back to the same? Is it essentially the same problem with no solutions? Remember, Little Sisters 1, and there was Little Sisters 2. Is this Little Sisters 3, so to speak? And I guess the third case is Dore, which was decided after Little Sisters, and which Justice Abella told us was supposed to solve these kinds of problems, but Vavilov seemed to say it will not be a relevant actor, maybe, or soon, is how I read Vavilov between the lines. So I guess where's Dore? Does it do any work? The lightness of the Charter of Rights in Dore existent in this case. Thank you.
Okay, I've been asked, Jamie, if you could turn your camera on so that you can join us here. Does anyone have any comments in response to these questions? Just some small issues,
yeah,
really.
okay. So I'll try to address that. I think what you see here is this turn to governing through discretion. So you can't talk about Vavilov now without talking about Dore and recognizing that to the extent that Dore counsels deference to the exercise of discretion, even where it engages charter rights, charter values, then there is reason for concern about how this would actually play out. That is compounded in the present case, of course, by the utter impracticability of ever actually being able to access representation or anything at the border where this exercise of discretion is allegedly going to happen. I mean, I think the larger issue, including from a rule of law perspective, is the incentives it creates to govern through discretion. If you, and I think Josh wrote this in our paper, if you just take a statute and add a line at the end and says the minister may, in their absolute discretion, exempt anybody from anything in the statute, does that mean that every provision in the statute now is constitutional and the only issue is about the safety valve discretion that exists at the very end? I mean, that's the larger problem that this raises. So I hope that provides some insight.
If I may, so one thing on the Dore question though is, and one hopeful note is in the Commission Scolaire decision, the court found Dore charter values sort of applicable and relevant, even though in that case, the claimants didn't have Section 23 rights. So in the immigration context, it's not clear. The court has never said, for example, that people facing deportation have their rights to liberty infringed or affected. But it might be under Commission Scolaire that you could sort of appeal to charter values, even if there's no explicit recognition of the engagement of liberty rights or life or rights to life, etc. So that is a somewhat hopeful sort of thing from the most recent word on Dore.
I think Jamie also wanted to jump in.
Yeah, I just wanted to comment that in a couple of weeks, the Supreme Court's going to be hearing a decision on our and TransAlta, and it deals with the fact of what's the standard of review of delegated legislation, which is what a lot of the immigration law context, the criteria programs are created under delegated legislation like regulations, ministerial orders and instructions and whatnot. And in that discussion, the government and some other parties are arguing that there should be a hyper deferential standard against that. And if we're going to be thinking about Vavilov and its legacy and in terms of these very complex administrative law regimes, it is interesting that there is distance being created in terms of accountability on these discretionary safety valves. So it's I think there is in the coming weeks, there's going to be some interesting discussions about how does Vavilov continue to apply in different contexts, especially in these very complex administrative legal regimes.
Any other questions or comments? So that people attending remotely can hear. Maybe I'll just get another question as we wait onto the table. I'm curious whether any of the panels we've heard a lot about safety valves being illusory. Do any of you have any optimism about ways that we might, if the Supreme Court is telling us the reason why this regime is constitutional is because the safety valves exist? Does anyone have any optimism about ways that we might actually say, okay, make good on that? And so the question, sorry, I was waiting for you to.
Oh, yeah. Sorry, my question was about, so the court spoke a lot about the United States and their asylum and refugee process. Now, if you're an administrative decision maker relying on, oh, perfect, sorry, trying to ascertain US immigration law and practice, my understanding is that US immigration refugee law itself has a lot of discretion. And Professor Macklin had rightly pointed out that the tenor of this decision is to kind of provide governance through discretion. And so if I am an administrative official in Canada, and I know that the United States themselves, based on who is in government this November or this January, could bend one way or the other based on the discretionary powers that they would have, then I'm trying to understand how that passes muster, right? Because we don't have a concrete kind of, let's say, ossified view of US immigration and asylum law, especially given the political changes that could be taking place in January and the discretion that administrative decision makers have, and the fact that the SCOTUS is currently reviewing a case about administrative deference in the United States that might be coming out in a few months. So
you add those shifts to the time question, how long does it take for one of these cases to move through the courts? It adds some additional complexity as well. So do any of the panelists have thoughts about either of those questions?
I'll just jump in very quickly in response to your intervention and just note that in theory, there's a monitoring regime that the government is accountable for that was built into the fabric of this agreement with the United States, which was predicated on the idea that, well, we've entered into this agreement now, but we can't assume that the United States is always going to be a safe partner for a responsibility sharing regime. So we will monitor and we will ensure that, in fact, the US government is living up to international standards. And in fact, there's a complete black box around the monitoring function. And that came out very clearly in every single court proceeding, but the Supreme Court didn't seem to care. And that really, I think, was a very serious concern.
And in the process of transition, let's say that the system is transitioning to, let's say the system is transitioning to a more restrictive approach. Let's say, given who is inaugurated in January, is there any retroactive application for those who the monitors thought were going to a country that was friendly and non-hostile to immigrants to kind of say, sorry, but now it is by the time you're sent?
Well, indeed, this is a question of the court catching up with what's going on the ground, right? And one of the challenges with litigation is that we're often looking retrospectively rather than what's in front of us. But no doubt the current context, once the federal court case is actually heard, is going to be in the air. So maybe there's some further thoughts to share about that, but that's it for now.
I'll just add the standard for the monitoring for when the US isn't a safe third country anymore, when you would de-designate is when circumstances require. So it's always always a resort to process, a resort to discretion. So and it can sometimes be.
Maybe I'll just jump in on making good on safety valves. I think my only thought, and it's not a particularly comprehensive one, is a claim for legal access to counsel at all stages of the process would put pressure on some of these safety valves that are supposed to be implemented, at the border in the circumstances that we're talking about. if one could actually make a serious claim for access to counsel, I would think that might actually make a difference in how these safety valves are operationalized, or frankly, whether they are operationalized at all.
And I think Jamie wanted to give it.
I know there's ongoing litigation around the safety valves issue, and I would hope and expect, and I think that during cross-examination of the evidence being put forward, the government is going to be put to task with regards to showing how things are actually operationalized, and what kinds of ways in which they can demonstrate that they are attending to.
We've lost you.
Advocates are putting forward. Sorry, can you hear me?
We just lost the last point.
I was just commenting on how I think there's going to be some interesting litigation going forward in terms of cross-examination of government and their expert witnesses about the operationalization of safety. They are responsive to the principles of fundamental justice. And so I think ongoing litigation will be illuminating in that aspect now that this has become such a big and live issue in charter litigation. And I would hope that the courts pay attention to that. And then I think one of the things I think is important is really pushing back on the test, and who has the burden and whatnot. It'll be interesting to see how that back end of the Section 7 analysis and the test develops over the next couple of years in litigation.
Thanks, Jamie. So I think I'm going to call it there because I know that I'm standing between you and lunch. But I'd like you to join me in thanking our panelists. I'm particularly grateful for the small bits of optimism that you shared with us. So thanks, everyone.